listening to the Hey Legal podcast.
CPD, when you want, where you want.
CPD for modern lawyers.
This free Hey Legal podcast is brought to you with the support of Caseload from De Novo Business Intelligence.
Hi and welcome back to the Hey Legal podcast. Ian Moir, convener of the Law Society of Scotland's Criminal Legal Aid Negotiation Team, has provided Hey Legal with an update for the profession on his discussions with the Scottish Legal Aid Board in respect to the current crisis and its impact on court business and the profession.
Hi, it's Tuesday the 24th of March and the team at Hey Legal have asked me to give you an update as best I can as to what is happening in the world of criminal law. For those of you that don't know, I'm Ian Moir, a partner at Moir and Sweeney Litigation in Glasgow, and I'm also the convener of the Criminal Committee for Legal Aid for the Law Society. Obviously, you'll appreciate that the situation is still fast moving and we're all trying to work out what's actually going to be happening in the future over the next few months while we fight the coronavirus situation. The first thing to say is that probably the single most crucial concession that we needed and asked for from the Legal Aid Board and the Scottish Government is the ability to make claims on an interim basis for fees for legal aid work. I'm pleased to say that very quickly there was an agreement by SLAB and the Scottish Government that that would be done, and work is ongoing by the Legal Aid Board to make sure that the systems can be updated to allow claims to be made in the very near future. My understanding is that there will be a rewrite of the legal aid online system to allow for a summary case to be claimed as soon as the case is delayed by COVID-19, probably by a drop-down box being added to the system. If for any reason that cannot be done quickly, I've asked that instead we are allowed to click the warrant box and thereafter indicate on an online message that in fact this is a COVID-19 claim. So one way or another, in the near future, firms will be able to make a claim for summary cases which are being adjourned. It seems likely from the latest practice notes coming out from Sheriff's Principal today that most summary business will be adjourned until at least August or September, with some being put off for even longer than that. It's a similar position in solemn cases where they're being adjourned for a number of months. In the High Court, for example, trials are being adjourned to continued preliminary hearings in late June with no trial fixed. So therefore, even in a custody case, any trial is likely to be several months after that. You will be able to make claims on your solemn accounts as well, but that requires slightly more process from the Legal Aid Board as to exactly how we'll be able to do that. But again, I would hope that in the relatively near future, in a number of days rather than weeks, we will be in a position to advise you as to exactly what you need to do in order to make a claim. One word of caution I would say is that obviously if you claim fees now and the case doesn't get disposed of for many months, you may be creating a tax liability and a cash flow problem further down the line. So I'm by no means saying don't claim the money, but it's important that you are mindful of any future tax liability and the ability to meet that. So those are positive steps. We are asking for other initiatives to be looked at, for example, around the current rules to do with duty solicitors and ABWAR for a custody appearance, given the health advice now is that we really ought only to be going in the most urgent of cases to court, and that we should be practising the proper social isolation whilst doing so. And also it would be clearly advisable to make sure that you're taking any steps you can in terms of hand sanitizer and so on to minimise the risk to your own health and to your family and other colleagues. It would appear likely that all other summary criminal business in all jurisdictions will now be adjourned administratively unless you contact the court to say there's a reason why that should not happen. The only exception to that will be is if the accused is in custody and wishes to apply for bail. Those cases will probably require an attendance at court, but I would certainly encourage you all to make your own informed decisions about the safety of attending court, and always have in mind the safety of yourself and your family. So be careful if you do have to go to court. Same applies to police station work. We are hoping that the Scottish Government will confirm today that we do have key worker status. Otherwise, if the lockdown becomes more enforced than appears to be the case right now, then you might find yourself in the invidious position of being stopped by the police while trying to go to a police station to help a client. Again, whether or not you attend and sit through an interview really will depend on what arrangements can be made to make that as safe as possible. And I would anticipate that the police will run as few police interviews as they can in the current circumstances. And those circumstances look likely to last for several months. So far as any other aspects of work are concerned, it's still a moving situation whether we will require to attend court for first diets. And again, it may be that written submissions can be made in those cases, and possibly also in cited cases which are capable of resolution, again subject to the board agreeing that we can make a claim for ABWAR in the circumstances where we're having to, rather than make an oral submission to the court, make a written one. That would clearly, in fairness to the board, require the consent of the Scottish Government and or emergency legislation. In terms of visiting clients in custody, so far as prison environment is concerned, the Scottish Prison Service have announced today that there will be no more prison visits for the foreseeable future. So all visits will require to be by video link or by telephone, and you may wish to think about writing to your clients to let them know that that is the situation, so that they can telephone your office if they need advice. It's unclear exactly how custodies will work, but it does seem highly likely that each sheriffdom will restrict the number of courts which are running, and there'll probably be 1 or 2 courts hearing custodies in any jurisdiction. And the Lord President has issued a practice note which allows for a video link from not only prisons but police stations. So it may be that in time the custody will remain at a designated police station and video link into the custody court. You can well imagine that there may be some practical hurdles for the solicitor if they're in a totally different building, perhaps even in a different town than their client, and trying to get access to limited video link facilities. But I think at a time like this, it's incumbent upon us all to make the best of what we can and to try and approach this in a collaborative spirit to try and ensure that the justice system can function as well as possible in the current circumstances, whilst protecting the health and safety of ourselves as key workers supporting the justice system. But these are all issues that we're looking at for you and keeping you as informed as we can. I will be tweeting as much as I can in terms of new information on @IanMoir5 on Twitter. So keep in touch with those developments. And as I say, it's very much a fast-moving situation, and I will try my best to keep everybody updated. But in the meantime, The key message is look after your staff, look after yourself, and keep your family safe. Thank you.
Thank you for listening to this Hey Legal podcast. We hope you enjoyed it. To hear the full CPD qualifying content, please visit heylegal.co.uk to subscribe and join our community. Or you could ask your law firm to contact us for a firm-wide subscription. Learn more, be more with Hey Legal.